欧洲谋求摆脱美国数字霸权。近期，欧洲数据监管机构向美国数字巨头 Meta 开出创纪录的天价罚单，处罚其违规数据传输行为对欧盟公民隐私造成严重侵犯。欧洲监管机构已不是第一次对美数字企业的违规行为进行警告，此次处罚也远不是欧洲第一次对美相关企业对欧洲的利益侵蚀做出强烈反击，数据传输更不是欧美间持续博弈与争夺的唯一话题，但其所反映的恰是欧美传统跨大西洋伙伴关系发展到当下无法回避的结构性难题。当地时间5月22日，爱尔兰数据保护委员会 DPC 对美国社交网络公司脸书母公司 Meta 处以12亿欧元罚款，处罚其将欧洲用户的脸书数据非法转移到美国，且未充分确保相关数据安全，认定其违反了欧盟通用数据保护条例 GDPR， 要求其在接到裁决通知的5个月内暂停向美国传输任何个人数据，并在半年内完成相应整改。据了解，欧盟此前曾于2021年对另一家美国数字巨头亚马逊的侵犯隐私行为处以 7.46 亿欧元罚款，而此次罚单也是迄今欧盟对违反数据保护条例企业开出的最重罚单。由于 Meta 的欧洲总部设在爱尔兰，故由爱尔兰数据保护委员会负责监管其在欧盟市场的数据保护事宜，并作出相关裁决。欧盟监管机构自2020年起就开始对 Meta 将欧洲用户的个人资料从欧盟转移到美国的行为进行跟踪调查，发现在被称为标准合同条款的法律工具中，并没有解决涉及数据主体基本权利与自由的相关风险。欧洲数据保护委员会 EDPB 主席安德里亚·耶利内克指出， Meta 的违规行为极为严重，是对欧盟公民个人数据的系统性、重复性与持续性的转移。脸书在欧洲拥有数百万用户，其传输的个人数据量是巨大的，希望通过巨额罚款发出强烈信号，及严重的侵权行为会带来沉重后果。Meta 方面则对此予以强烈抗议，并在声明中表示，将对不合理和不必要的罚款提出上诉，并通过法院寻求对这些命令的暂缓执行，强调这将为其他无数在欧盟和美国之间转移数据的公司树立一个危险的先例。欧美间围绕数据传输的博弈已持续多年，欧洲通过完善、细化司法条款规制美方，以促其尊重欧洲数据保护标准的尝试也已进行了多轮。早在2015年，在欧洲隐私保护领域的非政府组织及活动家的施压与上诉下，欧盟法院最终裁定欧美间于2000年签署的安全港数据传输安排无效，认为该协定无法阻止美国政府大规模访问欧洲公民信息。随后，欧美间就如何修复安全港协议终止后留下的条法真空进行了密集磋商，仅用5个月就草草出台了替补的隐斯顿协议。虽然美方声称对这一升级版的协议下尽苦功，并联合美商务部、国务院、联邦贸易委员会、交通部、司法部等部门共同站台承诺，但后续的种种事实表明，这份篇幅近130页的隐斯顿 安排最终难逃沦为一纸空文的命运。2020年7月16日，欧盟法院以美方无法提供与欧盟同等的隐私保护为由，否决了以隐斯顿作为向美国转移欧盟个人数据的法律依据的效力，认为美国政府在执行外国人监视计划时，虽以维护国家安全为目的，但仍存在以公权力访问个人数据等超出必要限度的行为手段，且违规比例失当。在安全港折戟、隐斯顿沉沙后，美数字巨头不得不使用欧委会发布的标准合同条款及2021年的更新版本进行数据传输，并不时在具体操作中寻求灰色的中间地带，而欧美也再次陷入了数据传输领域法律的黑洞。目前，欧美双方正继续寻求通过谈判推动一项新的数据转移协议，希望能在今年下半年达成，并紧抓今夏的窗口期进行密集对接。尽管美方仍在积极争取与欧洲寻求共识性、妥协性的数据传输协议，但当前的外部形势已于本世纪初发生了巨大的变化，欧美间的传统协调基础早已不同往日。随着此次达摩克利斯之剑最终落在 Meta 头上，部分来自欧洲的声音对未来欧美间能否真正彻底解决双方分歧持保留态度。有专家认为，必须清醒认识到，欧美间争议的核心正是关于欧盟通用数据保护条例与美国大规模情报监视行动间在法律上的严重不相容，彻底满足欧洲在数据保护方面的要求与美国不愿改变其所授权的大规模监控法律间的巨大差异性。业内资深律师索尼娅指出，美国太需要欧洲的数据了，以至于其未来很难接受欧方提出的任何更进一步的数据保护条款。如果说斯诺登曝光的美国棱镜门监听情报计划使欧洲开始对美国个人信息保护制度的虚伪性有了清醒认识，那么从2019年法国国家信息与自由委员会对谷歌处以约5000万欧元的罚款，到2020年谷歌与亚马逊被认定违反数据保护相关法律被处以 1.35 亿欧元罚款，从2021年7月亚马逊因隐私问题被卢森堡政府罚款 8.06 亿美元，到2022年 Meta 下的脸书与 WhatsApp 被处以重罚等种种司法重拳，显示出欧洲希望对美在数据领域的无序行为给予强硬回应，并以此为筹码促使美国正视与尊重欧洲的数据主权。作为欧洲战略自主的坚定推动者，法国在数据治理方面积累了丰富经验，也通过多年来在司法领域的积极尝试以及在产业领域的大力引导，希望向欧洲公司发出明确的政治信号，要么继续压住美国云，在客观上削弱欧洲部门，并对欧洲数据主权造成巨大破坏，要么自力更生，依靠 OVH、Orange、Telecom Italia 等欧洲本土云技术和基础设施，充分捍卫欧洲数据主权的安全与竞争力。有专家提醒，受多重因素影响，欧洲云市场持续增长的同时，欧洲本土企业在欧洲市场中的份额却在持续下降，并在4年时间中从 27% 下降至 13%， 且仍处于下滑区间。如今， 得数据者得天下已成为各方共识。在此背景下，欧美间围绕数据传输的多年博弈，其本质恰是欧美争夺未来先发优势，根源仍是欧美间仆从与反仆从、控制与反控制、美国优先与欧洲自主等多领域的不可调和的矛盾。其再次凸显出美方在多年固守霸权的过程中，早已过度透支了盟友的信任，传统跨大西洋伙伴关系失去了合作土壤与信任基础，也再次使外界认清了美国霸权的另一种形式，就是鼓动商业巨头，无视他国利益与安全顾虑，以贪婪的掘金为本，以傲慢的私利为主，持续侵蚀当地的经济发展红利。对此，欧洲能否真正以自主姿态捍卫自身数据主权，除了与欧洲决策层的政策和战略决心相关，更将考验欧洲未来在短期利益与长期发展、区内建设与全球参与、自主发展与对美规制等多方面的平衡水平与能力。
Europe seeks to escape U.S. digital hegemony. Recently, the European data regulator issued a record-breaking fine to the U.S. digital giant Meta, punishing its illegal data transmission behavior that seriously violated the privacy of EU citizens. It is not the first time that European regulators have warned U.S. digital companies about their violations, and this punishment is far from the first time that Europe has responded strongly to the erosion of European interests by U.S.-related companies. Data transmission is not a continuous game between Europe and the United States. It is the only topic of contention, but what it reflects is the unavoidable structural problem that the traditional transatlantic partnership between Europe and the United States has developed to the present. On May 22, local time, the Irish Data Protection Commission, DPC, imposed a fine of €1.2 billion on Meta, the parent company of the American social network company Facebook, for illegally transferring the Facebook data of European users to the United States and failing to do so. Fully ensure the security of relevant data, find it a violation of the EU's General Data Protection Regulation, GDPR, and require it to suspend the transfer of any personal data to the United States within 5 months of receiving the notification of the ruling, and complete the corresponding rectification within half a year. It is understood that the EU had previously imposed a fine of €746 million on another American digital giant Amazon in 2021 for privacy violations, and this fine is by far the heaviest fine imposed by the EU on companies that violate data protection regulations. Since Meta's European headquarters is located in Ireland, the Irish Data Protection Commission is responsible for supervising its data protection matters in the EU market and making relevant rulings. EU regulators have been tracking and investigating Meta's transfer of European users' personal data from the EU to the United States since 2020 and found that in the legal tool known as the Standard Contract Clause, it did not address the fundamentals of data subjects involved. Risks associated with rights and freedoms. Andrea Jelinek, chairman of the European Data Protection Board, EDPB, pointed out, Meta's violations are extremely serious, and they are systematic, repetitive, and continuous transfers of EU citizens' personal data. Facebook in Europe with millions of users, the amount of personal data it transmits is huge, and we hope that the huge fine will send a strong signal that serious infringements will have heavy consequences. Meta strongly protested this, and said in a statement, will appeal the unreasonable and unnecessary fines and seek a stay of these orders through the courts, emphasizing that this will set a dangerous precedent for countless other companies that transfer data between the EU and the United States. The game between Europe and the United States around data transmission has been going on for many years, and Europe has tried for several rounds to improve and refine its judicial regulations to regulate the United States, so as to promote its respect for European data protection standards. As early as 2015, under pressure and appeals from NGOs and activists in the field of privacy protection in Europe, the European Court of Justice finally ruled that the safe harbor data transfer arrangement signed between Europe and the United States in 2000 was invalid, believing that the agreement could not prevent the United States from governments access European citizen information on a massive scale. Subsequently, Europe and the United States conducted intensive consultations on how to repair the law vacuum left after the termination of the Safe Harbor Agreement, and a replacement Privacy Shield agreement was hastily introduced in only 5 months. Although the U.S. claims to have worked hard on this upgraded version of the agreement and made joint commitments with the U.S. Department of Commerce, State Department, Federal Trade Commission, Department of Transportation, and Department of Justice, various subsequent facts show that the length of this agreement is nearly 130 pages. The Privacy Shield arrangement of China cannot escape the fate of being reduced to a dead letter. On July 16, 2020, the Court of Justice of the European Union rejected the validity of the Privacy Shield as the legal basis for transferring EU personal data to the United States on the grounds that the United States could not provide the same privacy protection as the European Union. At the time of the plan, although the purpose was to maintain national security, there were still behaviors and methods that exceeded the necessary limit, such as accessing personal data with public authority, and the proportion of violations was inappropriate. After the collapse of the Safe Harbor and the sinking of the Privacy Shield, the U.S. digital giants have to use the standard contract clauses issued by the European Commission and the updated version in 2021 for data transmission, and from time to time seek the gray middle and specific operations zone. And Europe and the United States have once again fallen into a legal black hole in the field of data transmission. At present, Europe and the United States are continuing to seek to promote a new data transfer agreement through negotiations, hoping to reach it in the second half of this year, and seize the window period of this summer for intensive docking. Although the United States is still actively seeking a consensus and compromise data transmission agreement with Europe, the current external situation has undergone tremendous changes from the beginning of this century, and the traditional basis for coordination between Europe and the United States has long been different from the past. As the sword of Damocles finally falls on Meta, some voices from Europe have reservations about whether the differences between the two sides can be truly and completely resolved in the future. Some experts believe that we must be soberly aware that the core of the dispute between Europe and the United States is the serious legal incompatibility between the EU's General Data Protection Regulation and the US's large-scale intelligence surveillance operations, and the complete satisfaction of European data protection requirements. That's a huge difference from America's reluctance to change the mass surveillance laws it authorizes. Sonia, a senior lawyer in the industry, pointed out, the United States needs European data so much that it will be difficult for it to accept any further data protection clauses proposed by the European side in the future. If it is said that Snowden's exposure of the U.S. PRISM Gate intelligence monitoring program made Europe start to have a clear understanding of the hypocrisy of the U.S. personal information protection system, then since 2019, the French National Information and Liberty Commission imposed a fine of about 50 million euros on Google. Fines. By 2020, Google and Amazon will be fined 135 million euros if they are found to have violated data protection laws. From July 2021, Amazon will be fined $806 million by the Luxembourg government due to privacy issues. The heavy fines imposed on Facebook and WhatsApp show that Europe hopes to respond strongly to the disorderly behavior of the United States in the data field, and use this as a bargaining chip to urge the United States to face up to and respect Europe's data sovereignty. As a firm promoter of European strategic autonomy, France has accumulated rich experience in data governance. Through years of active attempts in the judicial field and strong guidance in the industrial field, France hopes to send a clear political signal to European companies: either continue to invest focusing on the U.S. cloud will objectively weaken the European sector and cause huge damage to European data sovereignty. Either rely on self-reliance and rely on European local cloud technologies and infrastructures such as OVH, Orange, and Telecom Italia to fully defend the security and competition of European data sovereignty. Force. Some experts reminded that due to multiple factors, while the European cloud market continues to grow, the share of European local companies in the European market continues to decline and has dropped from 27% to 13% in 4 years and is still in the decline range. Today, he who gets the data wins the world has become the consensus of all parties. In this context, the essence of the multi-year game between Europe and the United States around data transmission is that Europe and the United States are competing for the first-mover advantage in the future. Reconcile contradictions. It once again highlights that the United States has already excessively overdrawn the trust of its allies in the process of clinging to its hegemony for many years. The traditional transatlantic partnership has lost the soil for cooperation and the foundation of trust. Business giants, ignoring the interests and security concerns of other countries, are based on greedy gold diggers and arrogant self-interest, and continue to erode local economic development dividends. In this regard, whether Europe can truly defend its own data sovereignty with an independent attitude is not only related to the policy and strategic determination of European decision-makers, but also will test Europe's future short-term interests and long-term development, regional construction and global participation, independent development and international cooperation. The balance level and ability of U.S. regulations and other aspects.